Across America, BP supports more than 275,000 jobs to keep energy flowing. Jobs like updating turbines at one of our Indiana wind farms and producing more oil and gas with fewer operational emissions in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Content warning. This episode contains discussion of the murder of 2 girls.
There's been an awful lot of activity recently in the Delphi murders case, particularly owing to defendant Richard Allen's recent filing with the Indiana Supreme Court. Remember, he's on trial for the double homicide of Abigail Williams and Liberty German.
Previously, we've had on Brett and Alice from the prosecutors. They explained how things look from that side of the fence. Now we're going to get the defense perspective from Shay Hughes. He's an attorney who works as a public defender in the state of Indiana. He's active on social media as Hoosier Public Defender on Instagram and is Public Defender on Twitter.
Given all that's happened in the case, we wanted to check back in with him. In this episode, we will talk about the removal of the original defense team of Andrew Baldwin and Bradley Rozzi, Judge Frances Gull's possible recusal, and what might happen next in this case. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases.
We're The Murder Sheet.
And this is the Delphi murders. Richard Allen goes to the Indiana Supreme Court. A conversation with the Hoosier Public Defender.
Is it typical for a court case to descend into a prolonged legal battle between defense attorneys and a judge like this?
It is not typical for there to be some kind of prolonged battle between any of the parties and the judge.
And then I want to ask another basic question. What exactly is a writ of mandamus, and how do the higher courts typically view them?
A writ of mandamus or a writ of prohibition, it's original action. It's something that the Indiana Supreme Court would have jurisdiction over to ultimately decide. A writ of mandamus is essentially requesting the Indiana Supreme Court to order a trial court to do something. A writ of prohibition is an order not to do something. It's, as I mentioned, it's essentially asking the Indiana Supreme Court to weigh in on a particular issue. It's an extraordinary measure and should only be utilized when there's clear and obvious emergency that requires the Supreme Court to intervene and issue an order so a substantial injustice can be avoided. They're generally viewed with disfavor, should only be issued when the trial court has an absolute duty to act or refrain from action.
And just so our audience can follow along and make the distinction, in this situation involving Richard Allen's case and the Indiana Supreme Court, there are in fact 2 writs of mandamus, the first being having to do with improper record keeping rather, by Judge Gull, and the second one having more to do with recusing Judge Gull, getting the old defense back inside the case. Is that a fair kind of breakdown of the two writs?
Yeah, that's in its simplest form. Yes.
And we're going to get more in depth and go into a little bit more of the nuances and different elements there. But I suppose, given that these writs are typically looked on with disfavor, what's your assessment of using this measure and strategy to attempt to, maybe evoke some change in this case?
I will summarily say I favor both writs, and I agree with Alan's argument, particularly with the first writ. I think everyone knows kind of where I stand on the access, making the records publicly accessible, and I think it would be very, very difficult to defend Judge Gull as it relates to the accessibility and making records confidential. But again, we'll find out this week, I guess, what the argument is that she raises. I think there's an argument to be raised, but I just don't have, I don't find it that compelling. In reference to the second writ, I'm kind of a little bit across the board as it relates to the three issues that are presented. I do think there's a compelling case to reinstate the original attorneys that were appointed. In reference to the 70-day request to set a jury trial date after a writ's been issued, I don't have much confidence, that the Supreme Court would be inclined to do that, because essentially the parties can do so once the case, once the writ's decided, and they can seek that relief anyways. And then the recusal, is interesting, in asking for a new special judge. I think it kind of goes hand in hand with the first issue, right? If the attorneys are reinstated, then I think inherently you're probably assigning a new judge, because you're ultimately saying that the court, in some form or manner violated Alan's due process rights and how the court came to their decision. And, that alone probably is enough for a new judge to be appointed. But with that said, I'm not aware of any authority, and I think for the most part, when it comes to seeking a new judge, as far as a writ of mandamus goes, criminal defendants have not been very successful in such relief.
And actually, I think that the deadline for a response for the briefs in the Supreme Court case may have been moved back until after Thanksgiving.
So we're going to have to wait until the 27th now to figure out where the heck this all is going.
Right. For that second writ, is that correct?
Oh, yeah.
That's my understanding.
That's That's really interesting. And we appreciate your breakdowns of kind of each of the different asks, so to speak, in this. I suppose let's hone in on the first writ for a moment, because it definitely it's kind of interesting, I think, for all of us to see that one, because it actually involves the brief that you and Kevin, you helped Kevin with to get some of those filings and things that were improperly sealed released, and that's actually cited in that. And I guess, can you talk through what was improper about the record keeping in this case for folks who may not be super familiar with how that typically works?
Sure. Essentially, the Indiana Supreme Court, through the state constitution, has the ability to regulate itself, and inherently has the judicial power to administer justice, right? And the court has decided to issue a set of rules regarding the access of public records. The rules themselves essentially start from the presumption that records should be publicly accessible, then provides some guidance in reference to records that must be confidential, and then instances where it's discretionary, and provides basically a procedure if a particular party wants to make a record confidential. In this instance, I think the request that Kevin that filed ultimately lays it out in its simplest terms, that really none of the records fit Access Rule 5, which provides what records must be confidential. And then there's Rule 6, which upon a request, a record is temporarily confidential, and then a hearing has to be held and so forth. But that never happened in this case. There are a number of instances where the state had filed, a request to make records confidential, and, there was no real response filed by Allen. But there were a number of records that it appeared that the court on its own accord was making confidential despite no notice of exclusion form being filed. And that presents an issue because, again, you only have the authority that the Indiana Supreme Court has provided to you from those rules. There's nothing that provides that the court can decide on its own accord that records should be publicly accessible or remain confidential. So, I think the court has a tough argument to justify making several of those records confidential.
And I guess the other issue, I guess that's the dominant issue of the second writ of mandamus, is, of course, involves the removal of the attorneys. Does a judge even have the power, in your mind, to remove attorneys for gross negligence?
Ironically enough, there is a Supreme Court decision that came out and it was on a writ of mandamus, where two attorneys were removed from a case. And the court said that a trial court has limited authority to remove appointed counsel from a case, but it didn't really go into the parameters of that authority. With that said, that case was factually different than the facts presented in here. I would argue that if a court already has a limited authority to remove counsel from a case, they have even less authority or no authority to do it on its own accord. In this instance, Judge Gull's previous order citing a withdrawal conflict with the latest order of gross negligence. That's a standard that I've only seen used for civil liability cases, never to be used to disqualify an attorney from a case. And I think the bigger issue is that she came to this conclusion with essentially no proper notice, no evidentiary hearing, and I think there are some major due process concerns. And I think there's a policy argument as well as it relates to Allen's writ, that, if it's difficult generally for defendants to remove their court-appointed counsel, it logically follows that it should be even more difficult for a court. So, I think there's a compelling argument that Baldwin and Rozzi should be reinstated.
I'm curious in terms of, what you mentioned that, kind of a limited maybe situations where a court could do this. What high levels, speaking in a high level manner, what would that look like? You mentioned the due process evidentiary hearings. How would you expect that process to be followed if it was being, done in maybe a more proper way?
The authority, I think, would ultimately have to originate from one of the parties requesting the removal of counsel. So, you often see this, a defense attorney or even sometimes the defendant on their own accord will file something, citing a conflict, right? I mean, that would be a reason to ultimately remove and replace court-appointed counsel if there's some type of ethical conflict. Or, maybe the court knows, that an attorney is going to be on medical leave for an extended period of time, or, court receives notice that court-appointed counsel has been suspended, has been disciplined, right? I mean, those would all be reasons for a court to remove counsel and have the authority to do so. I mean, I think that would be justified. But again, I think the best practice, even in those situations, would be to hold some type of evidentiary hearing, provide notice to the parties, allow the various parties to present evidence, make a judicial finding that is based upon that evidence, and have the parties have an opportunity to, either file a motion to reconsider or an interlock appeal or so forth, right? Mm-hmm. That wasn't really done in this instance at all. And I think there was another issue too with Richard Allen himself, for reportedly not being present when this all transpired.
Does this violate his right to counsel? Does he as a defendant have right to counsel of his choice?
Well, indigent counsel does not have what I would say a full right to counsel of their choice, right? They don't have the same right as somebody that goes out and chooses their attorney. An indigent defendant would be very limited in the ability to have counsel removed and replaced. Again, it would be in those scenarios that I mentioned. The biggest being is if there's some type of conflict of interest. That the court-appointed counsel, some form or fashion is, conflicted because of prior representation of a witness or so forth. With that said, there is this issue out there now that Rozzi and Baldwin decided, they've ultimately filed a private appearance form, doing so pro bono, I think presents an issue separate, that now the court denied that private appearance, and there is case law from the United States Supreme Court that essentially says if you're interfering or denying somebody's ability to choose counsel, that in and of itself is a Sixth Amendment violation. And it doesn't matter how effective your counsel thereafter was in your case, because that alone, preventing somebody the ability to choose their counsel is a violation. So I think that is a separate issue and is a very significant issue.
Can you expand on that a bit? I think I saw in one of your posts on Instagram that you thought not letting them represent Allen pro bono had some policy implications that were quite negative.
Yeah, I think some people may think, well, how do I say this? That something that Baldwin and Rozzi, because they weren't privately hired as a traditional attorney, in terms of having some type of fee and so forth, and this is pro bono, may somehow negate that claim of the court, denying the ability to choose counsel. I disagree with that. I mean, everything that comes out from the judiciary encourages pro bono representation, right? And I think the court would be setting, if this became an issue, right? I think the court would be setting a terrible precedent to somehow diminish or, disfavor an argument where one is denied the right to the ability to choose counsel because it was going to be pro bono counsel. I think the court would be severely undermining itself and the judiciary as a whole if they were to even consider such an argument.
Here at the Murder Sheet, we work on the podcast and our investigative reporting full time. That means we sometimes don't have time to meticulously plan and cook delicious and nutritious meals. So, in this new year, we are eternally grateful to our sponsor, Factor.
Now's a great time to try out ready-to-eat meal delivery service Factor. Remember, when you support our great sponsors like Factor, you're supporting us and our ability to keep doing this work. So please consider visiting factormeals.com/msheet50 and use code msheet50 to get 50% off.
Factor allows you to pop your ready-made meal into the microwave. In 2 minutes flat, you'll have a hot and ready dish with minimal cleanup afterward. It's just that simple.
Also, this food is awesome. I recently dug their black bean and rice enchilada bowl with roasted zucchini, corn, and salsa verde. It tasted so fresh and flavorful.
I love that we get to skip meal prep, the grocery stores, expensive to-go orders, and elaborate cleanup. Plus, there's plenty of options for extra picky eaters like me.
We've really been thrilled with Factor, and we feel you will be too if you're striving to eat healthy and save time in 2024. It's really helped me meet my nutritional goals for the new year.
Head to factormeals.com/msheet50 and use code msheet50 to get 50% off. That's code msheet50 at factormeals.com/msheet50 to get 50% off.
I'm curious in terms of, we talked a bit about, Alan's rights in this and sort of the removal of these attorneys and whether or not that was proper or whatnot. But one thing that this mandamus is essentially asking for is for Judge Gull to be off the case. And you mentioned sort of maybe the law on that being somewhat unclear. But then again, when we're looking at this, she's disqualified them, basically indicated that she has lost confidence in them. Would there be any way for the trial to continue with her on if they were reinstated? That just seems like it would be really hard to see that happening, I guess. But I'm curious about what your thoughts are on that, legally speaking.
Oh, I agree with you. It would be very difficult to envision that, where essentially that second writ is kind of split, right, where the attorneys are reinstated, but Judge Gull remains on. What I will say is that the test for recusal is whether an objective person would have a reasonable basis for judging or a reasonable basis for doubting the judge's impartiality, right? And it's presumed that judges are unbiased. It needs to be something more than an unfavorable ruling. But, I think there is a very compelling argument that he should be recused. I mean, essentially presented an ultimatum to counsel to withdraw, or a hearing would take place with the court finding Alan's attorneys to be grossly negligent. And removal certainly places Alan in jeopardy, as he reportedly intended to proceed to trial in January. Now the case is pushed back to October of 2024. This kind of goes back to the due process, what I believe are due process violations, that, the judge made improper comments. He told the attorneys to keep working on the case. She cited that essentially how she didn't really care for the representation. I think some folks would view that as she took control of the case and was almost presenting herself as an advocate for the state. She came to this conclusion regarding the adequacy of representation without any type of evidentiary hearing, without the ability for the attorneys to present any evidence, and then doing so in an in-chamber session where Alan reportedly was not present. So I think the record provides that her actions and demeanor essentially crossed the line. And I think that she's failed to preside as a neutral and impartial decision maker, to handle this case in the future.
And so that would lead to potentially her getting kicked off, essentially, if they do prevail in coming back.
That's correct. Again, summarily, I think that first issue, the reinstatement and Judge Gull remaining on the case they go hand in hand. It's difficult for me to square away a situation where Baldwin and Rozzi would be reinstated, but then Judge Gull also remains on the case. I would have a hard time because I think the reasoning for both is almost identical, right?
Mm-hmm.
And I think it would kind of defy logic if there was a favor in one way and then denying the writ the other way.
And one thing I just want to wind back the clock a little bit, because all of this legal wrangling is incredibly interesting, but I also want to just maybe ask you, in terms of the original sin of this whole situation, which is defense admitting to a former colleague of Baldwin's getting improper access to crime scene images and leaking them. And also in Rozzi's letter, he also indicates that Baldwin shared strategy with this man, Mitch Westerman. Have you ever seen anything like that before? And have you seen, if so, have you seen other ways of maybe dealing with it, like sanctions, stuff like that?
Well, I've never seen something like this happen. And I can tell you personally, and there's another colleague of mine, and her and I kind of have the same philosophy where I really do not like talking to about my case to anyone else short of my client.
Mm-hmm.
And I ultimately, I get a lot of resistance from family members and sometimes even the client. Why aren't you talking to my friends and family? Well, there's a reason for it. If you want to leak out strategy and talk about your case, that's one thing, but I'm just not going to be involved with it. And I don't know who those folks are talking to and so forth. And that's why I think it's the best practice is just simply talk to your client, your co-counsel. If you have an investigator here and there, discuss things, but really limit who you're speaking to about your case and leave it at that. I've never seen this issue present itself, but again, I've only been practicing now for 10 years. There is a way of handling it. The way to address it would be through contempt proceedings. Now, this is what's known as indirect contempt because it happened outside of the court's presence. But as part of any in contempt, for someone to be found in indirect contempt, there would need to be a showing of willful disobedience of a court order. And I think that's somewhat of an issue. Talking strategy with somebody, the evidence leak, it's certainly negligent. It may even be reckless. Was it a willful disobedience of the court's order, the gag order? I think it falls short of that personally. And I think there's somewhat of an issue because that order, correct me if I'm wrong, says, means of public communication. What does that phrase really mean?
Right.
It sounds like Baldwin was talking to a private individual.
Pardon me if I'm getting this wrong. Kevin, correct me if I'm wrong. I think the violation was of the protective order. Is that right? Versus the gag order?
Yeah.
Just to get the terminology. I think we read something, and I have to go back through our notes on this, but it was almost indicating that anybody who should be handling discovery would need to sign some sort of sign something and then have the judge approve it, that they would have access to it.
Sure.
And I think that's maybe more of what was at issue here rather than the gag order.
Well, even with that, setting that aside and noting it,
Mm-hmm.
I think there's an issue of willful disobedience.
Oh, yeah.
Now, even if there is willful disobedience, the indirect contempt statute, in terms of what the court can do as a sanction, is limited. It's imprisonment, fine, or fine and imprisonment. There's nothing that calls for the removal of counsel as a sanction. And I give Baldwin credit. He, through his attorney, David Hennessy, presented what I thought was very fair sanction of essentially 24 hours of work that would be, non-payable. Because, I personally believe, based upon what I know, that I just don't think there's willful negligence or willful disobedience on the part of Andrew Baldwin. But, that's just my opinion. But again, we didn't even get that far, right? I mean, no information was filed on behalf of the state. The court, essentially went on their own volition to remove counsel.
Right. It was done behind closed doors and, without the presence of even Richard Allen, seemingly.
And another thing people have questions about is how the two new defense attorneys were chosen and appointed. Do you have any concerns about that?
Well, I certainly have some concerns about it. It's funny because I think if you were to talk to anyone part of the Indiana Defense Bar, and again, I don't want to speak for everybody, but leading up to the assignment of new counsel, I think everyone thought the optics would look awful if counsel from Allen County was appointed. I don't personally know the newly appointed attorneys. I think they're going to represent Allen zealously, but the appearance is bad that you're replacing old counsel. You're in the same county as Judge Gull, who went on her own volition to remove prior counsel. You have pending cases before her. You're going to continue to receive cases that are going to be before her. It makes for terrible optics, on top of one of the attorneys publicly commenting on the case and, making comments that were favorable for the state. People are going to question, I guess, the level of representation that Allen receives now.
Yeah, that is certainly concerning regarding those public comments. I'm curious, do you think that, this is obviously such speculation. You don't know these attorneys, and so I'll just ask it, but noting that this would be speculation, I guess, do you think that the new attorneys, will they be boxed into going with, if they stay on and the old attorneys do not succeed in coming back, will they be boxed into the Odinist theory and what was outlined in the Franks memorandum, or do you think they have a chance to do whatever they want and kind of go forward? I'm just more of thinking about this from a public relations standpoint and like whether it would look bad to switch, or do they have an opportunity because they are new counsel?
They have the opportunity because they're new counsel, in terms of strategy. That's under their control. Defendants really limited in terms of their choices. Summarily, the right to either plead guilty or go to trial is Richard Allen's decision. The decision of whether or not to do a jury trial or versus a bench trial, and that right is somewhat limited. But again, that's a decision for Richard Allen. The decision ultimately to whether or not to testify or not would be Richard Allen's decision. The decision whether or not to appeal any conviction and sentencing thereafter, again, would be his decision only. So he's really limited in terms of about 4 significant decisions. Trial strategy itself will be controlled for the most part by counsel. In terms of how it would be publicly perceived, in this Odinist theory and all that, it's kind of difficult to say. I don't put too much into that, whether or not they pursue that angle or not. I think any defense would likely entail essentially defense counsel putting somebody else on trial, putting another suspect on trial, so to speak. Mm-hmm. And the odorous theory kind of touches on that, right? What I would be very concerned is if the motion to suppress is withdrawn. I think public perception would vastly change, and I think people would be very concerned and would not view a decision like that very favorably, because I do think there are, given what's been presented, that the motion to suppress does have merit. That it appears that that information was recklessly omitted from the affidavit. And the question then becomes, with that information included, is there still probable cause to believe that Allen's home contained, evidence as it relates to the murder of Abby and Libby? That's a difficult question to answer. I see it from both sides on that one. But I think folks would not think very favorably if the motion to suppress was ultimately withdrawn.
Yeah, I think that would look like a pulled punch. And I imagine that no matter what theory they end up going with or what strategy they end up going with, you're going to have to really try to get that gun thrown out no matter what and attack that from every angle you can.
Yeah, I get where his attorney's coming from about tool marking. Again, my difference is it's likely going to be admissible, right? Just given prior case law. The question is whether or not you can discredit the weight of that evidence. But I still think you should make a record of it. And I think there is some persuasive authority out there in terms of the admissibility. But the difference between myself and Allen's new counsel is, if I was asked to appear or, make an appearance, while I personally believe I would zealously represent Richard Allen, I would refuse taking this case because I have made numerous public comments about the case, and I do not want anyone questioning the representation that Richard Allen receives. It's not fair to him.
Yeah, that makes a lot of sense. I wonder, this is again speculation, do you have any idea what's going to happen next in all of this?
I really don't. It's probably not fair to anyone for me to speculate. I would hope we would have some type of order issued as it relates to the writs, by mid-December. But again, take that with a grain of salt. I have not really reviewed and looked at the case law as it relates to the writ of mandamus and how quickly those writs are denied or issued. But, given the timeline that they've kind of created, and I think that may or may not be a strategy of theirs of referencing the 70 days and so forth. I would hope that we would get something out by mid-December.
And I'm curious if the old defense team essentially fails through these means to come back to the case. If that aspect of this is denied, then do they have other means of potentially trying to come back, or is this pretty much it?
I think it's pretty much it as it relates for now. Mm-hmm. If Richard Allen is convicted, then this issue will certainly be raised on appeal. As far as I'm concerned, I personally believe that this case, if the issue is raised about denying the ability to choose counsel, I think he will be successful on that. I just don't see how an appellate court could square that issue away and say, well, it's pro bono and they were disqualified and so forth. I think there's a bad record being set in this case, and I just cannot see an appellate court somehow saying, well, that he was not deprived the ability to choose counsel. So really, really limited. It would ultimately, he'd have to be convicted then to raise the issue. But I do think it is an issue that he will be successful on.
So we could see all this raising once again whenever this actually gets adjudicated. And one kind of follow-up question on that is, had Rozzi and Baldwin been allowed to remain on and he was convicted, would he have been able to raise the leak as evidence of ineffective counsel? And how do you see that playing out if that had happened?
He may raise the effectiveness of counsel, but it's difficult. I'll say this: even if Baldwin and Rozzi, if they filed what they filed and they went through with the hearings and so forth, and they didn't do anything more than they've already done, there's a substantial likelihood that they would be found to be effective counsel. I don't think the public truly appreciates how difficult it is to be found ineffective. And how do I say this? When cases involve children, I think it's even more difficult. You don't see many cases being reversed. Whether or not, appellate courts are holding, defense to a higher standard or not, that's up to you to decide. But you don't see it often. I mean, you really don't. It's extremely difficult. So, I just, even if they were to continue on the case, I don't see, that being a claim that has much merit.
Understood. Well, Shay, is there anything we didn't ask you about that you wanted to mention, or you just think is important for helping the public to understand this ongoing, very complicated situation?
No, that's really it.
Thanks to Shay for sharing his insight and time with us.
Follow the Hoosier Public Defender on Twitter at @publicdefender_, or follow him on Instagram at Hoosier Public Defender.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.